Hey, what's good, everybody? This is Carl. Hope everybody's having a great day. Today, we're going to be in the courtroom of Judge Tammi Long Hayward out of Clayton County, Georgia. All right. So let me just first off say this is not a sovereign citizen video, but this is a guy that's pro se. He's representing himself. It involves a dog bite, and I think it's a really good case. I actually sat in on her court hearing today, and I came across this, so I decided to share it with y'all. All right. Unfortunately, there's not sovereign citizens going to court every day, so rather than keep digging up old stuff, I said, let me throw something up here new, but it's not a sovereign citizen case. But either way, I enjoyed it. I hope you enjoyed it. I found it interesting. So let's get to this proceeding.
All right, Chancey versus Hudson.
Yes, Your Honor. This is a dog bite tort claim, and this is a discovery motion to strike Mr. Hudson's answer. I don't want to rehash the brief because I think we kind of go through the timeline on that already. But essentially, it's no responses to written discovery, 3 depositions missed. Well, sorry, excuse me. 2 were attended, but both had objections to providing any information to us. The third one was missed after we obtained an order from you ordering Mr. Hudson to deposition. It's a 2022 case. It's been pending for almost 3 years now. There's no insurance. The landlord's defaulted. And so we think the only sanction that cures the prejudice here and allows us to move forward with the damages hearing is to strike the answer. Otherwise, the other sanctions available, like awarding attorney's fees and things like that, Mr. Hudson's probably not going to be able to pay those, and they're not going to put us in the position that we would have been in if the discovery was had. So I know it's a harsh sanction. I know that he is pro se, and that's why we're not asking for fees in addition to striking the answer. But when you exercise your right to represent yourself, you're treated to the same standards that attorneys are. And if it were my client that did all of this, that, as we laid out in the brief, I don't think you'd have a problem dismissing our case for want of prosecution. So that's why we're asking for that sanction.
All right. So, Mr. Hudson, you understand what Mr. Samuels is asking me to do?
No, ma'am.
Okay, let me explain it. So this is the issue with representing yourself, especially in a civil context, because it is very, very technical. But when a civil case is filed against you, and you have you answer that case, that means you're putting yourself into the litigation, which means that they have obligations to you, you have obligations to them. Part of that obligation is under discovery, which means you will exchange information, and there are rules to it. But they get to send you questions, they get to send you statements that you have to verify, they get to have depositions where they ask you questions regarding anything that could lead to information that might be relevant and produced at trial. And so all of those things, they have that responsibility, and you have that responsibility. My understanding is that they have tried to engage in discovery with you, and you have been what is essentially non-responsive. They've set up depositions, and you've refused to answer or provide relevant or information that might lead to information that is necessary for trial. And so with that being said, I can't treat pro se litigants any differently than I treat people who are trained in the rules of procedure, evidence, who are attorneys essentially. So if you put yourself at a disadvantage when you don't have an attorney, and I know attorneys are expensive, but what we do, as attorneys, is we understand the rules. And so we know how to guide you by the rules. And my mom's an attorney, and she says a lot of her clients say to her, well, it's just talking. I mean, I know how to talk, but do you know how to say the right words? Do you know?
Well, see, I really never understood when he was calling for the dispositions. I never really understood what disposition was. I never went through it, never had to deal with it. I thought once I sent the copy of the video to the courts, because he was asking for a copy of the video, well, I turned it over to the courts. It's at the courthouse.
Yeah, that's not a good answer. I mean, if you're going to represent yourself, I mean, it's simple. Looking up whatever the word it is that you need to look up is just a simple Google search. Get a clear understanding from the Google search. Maybe do a little bit more research. But if you're going to represent yourself, then he has to understand that some research is going to have to be done. because lawyers, even though they went to school for for however many years for law school, they still have to do research. So yeah, that's just not a good answer.
Don't have a copy of the video. The video is literally when I answered to their question. I figured once I answered their question and answered it with the video, that the courts would give him the video. I didn't know that I had to provide him a copy of the video, but
Yeah.
the video is at the courthouse in the file.
Unfortunately, Mr. Hudson, that's not how it works. So we're the courts are the neutral party. We stay out.
Yeah, one thing about Judge Tammi Long Hayward, she somehow works in a very good explanation to the defendants, to the plaintiffs, to whoever's involved, about why their argument or their logic or whatever it is isn't going to work. That's one thing I love about her. She's definitely a no-nonsense judge, but at the same time, she's fair, and she kind of educates you as you're going along.
Out of it as much as possible. I hear as little as possible until you all come to me for either a motions hearing or a trial. And so all of the responsibility for the litigation of a lawsuit is between the parties. So Mr. Samuel says he's done his part, but you failed to do your part. And he's asking me now to change your posture in the litigation. He's asking me to remove your answer and put you in a default. And if I put you in a default position, that means you have not answered. There's no dispute. Mr. Samuels will win by default. His client wins by default, and he will ask me for a judgment. All he'll have to do is prove the damages for the judgment. Now, you still have the opportunity to weigh in on the damages phase. If I were to do that, you could say that I've paid this or I challenge this as with respect to damages. But essentially, if I remove your answer, he wins the case. I don't mind explaining as much as I can, but the problem when you represent yourself is you don't understand things like the responsibility to participate in discovery, what a deposition means and what it requires of you, what it means to turn over discovery to the other side. So the courts, you don't have to, you can file discovery with us, but the most important part is exchanging discovery, sending it to the other party, them sending you what you asked for.
Okay. But I explained to him that I didn't have it. I explained to him that it was at the courts. When we went in the first deposition, I explained to him that I didn't have a copy of the film. It was at the court. I don't know how to go back up there and get it from him. What do I go ask him for it back and then send it to him? But I don't know how to go up there and get it. I turned it in when I turned it in with the answer. I figured once I answered and gave them a copy of the film that was me answering him and giving him what he needed. Now I understand you're telling me now that it don't work like that. I do understand that now. But that's how I figured that was my answer was answered, because if had I known it, I would have kept the video for myself, and then I would have been able to present it had I known that's how it goes. But I didn't know it, and I understand that you're explaining it to me now. But when he was asking me questions, I was thinking like he was just, I don't know, just trying to build the case, really, honestly. So that's why I refrained from giving him any of the information, because I felt he was trying to build a case. It was like being attacked. So that's what really kept me from even talking to him, period, at all. But it is, like I said, it is a video on file that's showing where the Chancey did whatever he did. I'm not saying that the dog did not bite him, but I'm saying that he was aggressive towards the dog. That's what shows on the video, that he was aggressive towards the dog, and that's what made the dog attack him. So I figured once I sent that into the courts, and one say this case was dismissed in another court. It had been dismissed, but I understand.
Mr. Samuels, do you have the video that he's talking about?
I don't, and I'm concerned that if it's been spoliated, even if unintentionally, that's really going to prejudice my client's case at this point. It's direct evidence of what happened that day.
Okay, I'm not sure where he said he brought it down to the court. I don't know what that means. I don't know what form it was in.
Okay.
I have every confidence that our state court clerk is stellar when it comes to preserving documents and submissions. Even if they're in video form, she will take whatever they give her and maintain it in the way that it was given. However, I don't know what was given. There's no way for me to know that. If you can access whatever the clerk has, that's fine, but I'm not sure how this all went. But like I said, I don't have any idea of how this all kind of went. But unfortunately, Mr. Hudson, the part that I guess is most important is I can't treat you any differently than I would treat Mr. Samuels' client if he did the same. So if you sued Mr. Samuels and he said, my client's not answering any questions, I'm not participating, and I've had some attorneys do that, we've had to walk them back to what the rules say. But I can't, because you're pro se and you didn't know, I can't use that as an excuse to not respond to the motion that Mr. Samuels has had.
Okay.
Okay. All right. It's not, I don't know. It's hard, I know, because what people see on TV about how cases go, what they understand from the barbershop. My husband and I joke all the time about barbershop law versus actually law. And at some point, we're going to talk about that. I may do a podcast when I retire, because what they tell you in the barbershop or wherever you get information about how a case goes, it is so different from the way a case actually goes. And so, yes, Mr. Samuels was attempting to get information for his case, but you have the same right to get information to defend your case. And you got to know how to do that. So at this point, Mr. Samuels, I'll go ahead and grant your motion. So both Mr. Hudson and the court, I guess the landlord are in default. I would like to place the damages hearing on another motions date, because Mr. Hudson does have the opportunity to challenge any damages that you assert from your client. If he has documentation, if he has anything, video, even if he wanted to present it, or anything else with respect to the damages hearing, then I would prefer to have it at a different time.
Yeah, I think that's fine. I just need to confer with my client because we originally filed a jury demand, and what I want to ask him is whether he's willing to withdraw that so we could do a bench trial and get it done more efficiently that way.
Either way, a bench trial, jury trial, either way, but it's going to be on another date.
Okay.
All right. So I think we have your motion, your order, your proposed order. So,
can I ask how many days do I have before I can challenge the order that we're signing right now?
Once you get it, you have 30 days to challenge it. But Mr. Hudson, this is where it gets important. There are rules to this, and so just you saying I just want to challenge it, that's one thing, but challenging it properly so that you actually can have an effect that you're looking for, that's different.
I got you.
Okay.
Yes, ma'am.
All right. You're excused at this time.
Judge, before we excuse these parties, is Mr. Samuels going to file a motion letting us know how we're going to move forward, and then we'll file an order about what happened here today, or do we go ahead?
No, we'll go ahead and file the order granting the default, and then Mr. Samuels just can send us an email or file something saying that he wants a bench trial versus a jury trial, or he wants to maintain his jury trial.
Okay, yes, ma'am. Thank you.
All right. And Mr. Hudson, please be mindful that whatever the next step is, you'll be getting notice from the court, okay?
Okay, thank you.
All right, thank you.
Bye-bye.
Thank you.
All right, y'all. So that's the end of the proceeding. Unfortunately for Mr. Cedric Hudson, he's definitely in over his head. Judge Hayward, she pretty much gave him the spiel like she does with sovereign citizens, but in this case, he's pro se, and he's making some mistakes, and he doesn't understand some of the process. All right. So one thing about Judge Hayward, she's a no nonsense judge, but at the same time, like I said earlier, she's definitely fair, and she explains the process to you. All right. So with that being said, if I could bring you more of this case, I definitely will. Like I said, it involved, or maybe I didn't say it, but it involved a dog bite, and I guess the whole situation is on video, which, for whatever reason, he turned it in to the courts, but did not keep a copy for himself. And that's where the inexperience of not going to law school comes in, or at least not doing the research. But with that being said, I just want to thank you for watching. Like, comment, subscribe to the channel, hit the notification bell if you want to continue to see court cases like this. All right, this is Carl from Sovcits and Chronicles. I catch you on the next proceeding. God bless. Peace.